Now we continue with Professor Michael Geistlinger. As I mentioned, he's a retired professor of the international law at the University of Salzburg, and he will explain now that the EU had no competences for creating the European Health Emergency Preparedness and Response Authority, HERA. Please, Professor.
Thank you very much. Distinguished members of Parliament, ladies and gentlemen, by the EU Parliament's resolution of 21st October 2021 on EU transparency in the development, purchase and distribution of COVID-19 vaccines, the EU Parliament expressed its deepest regret on the lack of transparency from the Commission, the Member States and pharmaceutical companies. In addition, the EU Parliament asked for further measures providing transparency. In particular, it criticized the Commission's decision to refrain from using the ordinary legislative procedure through Article 168 TFEU in setting up the new European Health Emergency Preparedness and Response Authority, as HERA is called. The EU Parliament's concerns were more than justified. Whereas HERA should have become operative only in 2023, it became operative already on 8 December 2021, and is considered the core of the new European Health Union and Pandemic Preparedness and Response System. HERA places itself in the center of the argued EU's improved reaction to COVID-19 and in the efforts of the EU to become the leader in strengthening global preparedness for future health emergencies. HERA links its activities to the definition of serious cross-border threat to health by the respective EU regulation and profits from them. Serious cross-border threat to health means a life-threatening or otherwise serious hazard of health of biological, chemical, environmental, or even unknown origin. By referring to the EU Global Health Strategy of 30th November 2022, HERA considerably expands its mandate. This strategy addresses health as a global good, being impacted by the triple planetary crisis of climate change, biodiversity, and pollution. By means of reference to regulation and strategy, HERA provided itself with superpowers in the area of health, embracing everything. Health combining climate change, environmental pollution, and even nuclear fallout. Looking at the first anniversary's report on the activities of HERA, I could give you a great number of examples how HERA expanded its activities and is indicating a further expansion in future. Just to mention one example, HERA obviously follows the proposal of the Special Advisor on COVID-19 to the European Commission President, Peter Payot, to replace the term COVID-19 booster vaccinations by seasonal vaccinations, like for influenza, and included influenza in pandemic, having concluded on 28 July 2022 a joint reservation contract for 85 million doses of pandemic influenza vaccines. HERA's announcement of the deal reveals its understanding of pandemic when it states, I quote, "An influenza pandemic would be a global epidemic caused by a new influenza strain to which there's little to no pre-existing immunity in the human population." The contract is just the beginning, as HERA aims to expand inter alia on medical devices and laboratory materials. Let me thus please submit the question which could be handed over by the present members of parliament to the plenary. Why does the EU Parliament silently tolerate whatever HERA does? But there are two other questions which are more complex and are very linked on the legal side to this first question. Why did the EU Parliament refer the EU Commission to Article 168 of the Treaty on Functioning of the European Union, TFEU, I will just call it, which, as all the other articles in the TFEU, do neither provide the Commission nor the Council, but I apologize, also not the Parliament, with any competence to adopt legislative acts in the context of a pandemic. Why did the EU Parliament agree to base legislative acts in the context of a pandemic on poor references to articles in the TFU and TEU using the word health, instead of verifying whether those articles do indeed assign the EU and its bodies the respective competence? Is not lack of competence worse than lack of transparency? As for the competence of the EU in health matters, the fundamental norm is Article 168(5). Besides adopting measures on the EU level as incentive measures, even when it comes to combating serious cross-border threats to health, no delegation of competences by the EU member states has taken place. The aim of achieving a high level of health protection laid down in Article 161(1) cannot overrule the limits to the EU by the same article. Union action is restricted to complement national policies, not to replace them. The EU member states are led to cooperation in between themselves, which cooperation shall be supported by the EU. Article 168(2) para 2 mentions guidelines as an example for a useful initiative to promote such cooperation, but not regulations, not decisions, and even not directives. The Council is expressly allowed to issue recommendations for the purposes set out by Article 168 TFEU. Legislative measures adopted in the procedure for ordinary legislation that reach further are restricted by Article 164 TFU to 3 matters: setting high standards of quality and safety of organs and substances of human origin, blood and blood derivatives, in the veterinary and phytosanitary fields, which have as their direct objective the protection of public health, and finally, setting high standards of quality and safety for medicinal products and devices for medical use. There is no provision in this Article 168(4) related to measures for early reporting, monitoring, and combating serious cross-border health threats, particularly in the case of pandemics. Thus, to use the instrument of a regulation based on Article 168(5) TFU must be considered overstepping the limits of competences of the EU bodies. The reference to Article 114 TFEU in the context of EMA, setting EMA within approximation of laws in the internal market, can only be understood as desperate effort to find any respective competence in the EU, which in fact is not given. Even if the protection of health is considered as cross-section matter according to Article 9 TFEU, which has to be considered whenever the EU bodies become active, according to the jurisprudence of the European Court of Justice, Article 114 TFEU must not be used to circumvent the explicit exemption from approximation of laws under Article 168.5, with the exceptions of Article 168.4. Measures to fight pandemics like COVID-19, even subsidiarily, cannot be based on the internal market competence of Article 114.1 TFU. Legitimate doubts may be raised also as to the current negotiations on a World Health Organization's pandemic treaty and a package of amendments to the international health regulations. In both cases, the EU has taken the lead at the pandemic through the European Commission, at the international health regulations through the EU presidency. It must be doubted that the strong negotiation power of the EU is in line with Article 168.5 TFU, which provides that, I quote, the Union and the Member States shall foster cooperation with the competent in the international organizations in the sphere of public health. With regard to the World Health Organization, the EU has become active on behalf of its members and not in cooperation with them. Given the understanding of health as human health, as opposite to animal health, in Article 168.5 TFU, also the One Health concept of the EU, underlying its internal measures with regard to pandemic preparedness and prevention, and its impact to the negotiations of the pandemic treaty and package of the World Health, international health regulations, must be put into doubt as overstepping the limits of the EU's and as a consequence also HERA's competences. To enlarge the understanding of threats to health to also include environmental threats, thus cannot be based on Article 168.5 TFU, but must be in line with Article 191.1 TFEU, which is to be applied only in such a case. Article 109.1 TFU entitles the EU, however, only to adopt an environmental policy measure which pursues inter alia the object of protecting human health, and not a human health measure meeting an environmental threat. As far as reference is made to Article 35 European Charter on Fundamental Rights and Freedoms, the provision must be understood as not enlarging the competence of the EU and its bodies. It obliges them to pay due respect to this article when using their competences, inter alia under Article 168 TFEU. Since HERA is built by the European Commission on its own competences as to health, the lack of a legal fundament for the European Commission's and the EU's respective activities also leads to HERA's lack of legal basis. Focusing on the fight of pandemics leads to the fiction of a permanent crisis mode and the respective rearrangement of financial resources and personnel capacities. This makes regular health care in the EU member states suffer and detriments EU people. The EU Parliament is thus urgently requested to return to what it has been delegated to do by the EU member states and stop all EU bodies, in particular HERA, from continuing as to pandemics to act ultra vires. Thank you very much.